Thank you very much, Honorable Attorney General. Honorable Prime Minister, Mr. Gaston Brown, Honorable Speaker of the House, Mr. Jerry Watt, Honorable Attorney General, Honorable Ministers, legislators, members of the head table, the Registrar of the Supreme Court, I see former Judge Albert Redhead and his dear wife, June, and other distinguished guests, ladies and gentlemen. Greetings. I am absolutely honored to be here at such a very large turnout of people from Antigua and Barbuda to discuss the issue of the Caribbean Court of Justice. As President of the Court, I think one of my responsibilities is to provide information to people throughout the region and beyond about the court, about what we do, about how we do it, about the institutions that support the court, and about perhaps some of the cases that the court has done. Because for the people of Antigua and Barbuda, the CCJ might seem to be an idea, a concept, something that you could wonder, well, is it a good thing or is it a bad thing? But for the people of Barbados and Guyana, the CCJ is not an idea. It is a living reality. They live the CCJ. They can tell you about the CCJ. They have been sending their cases to the CCJ since 2005. The country of Belize, they have been sending their cases to the CCJ since, I believe, 2011 or 2012. The country of Dominica, they have been sending their cases to the CCJ from last year. So that the CCJ, and I want to stress this, it is very important, is not an idea. It is a living reality. And so when you have fairs, you can turn to the people who live that reality and find out from them, have you experienced those fairs? Have the fairs that you have been realized? What has been your experience with the CCJ? Has the CCJ been susceptible to political pressure in your country? We can ask those questions and get answers. We don't have to speculate. So that's the first point I want to make. Now, the Honorable Attorney General began to do a little bit of this, and I want to do it as well. Because you see, when you're engaged in an important exercise, it is important to look at the historical antecedents. It is important to look at where you're coming from and where you are now and where you want to get to. It is important to do that so that you have a proper bearing on your situation now. So, as he pointed out, the Privy Council, as we know it, was established in 1833. In 1833, my and your great-great-great-great-grandparents were slaves. We were not regarded as people. We were bought and sold in the market like cattle, like hogs, like donkeys, like chicken. That is a fact. The Judicial Committee of the Privy Council was established as part of the colonial apparatus that countenanced that system. In 1834, we became people. We were no longer chattels. In 1834, they took the shackles off and they said, well, you are now persons. You're no longer chattels. And that has been referred to as Rex Nettleford, by Rex Nettleford, a very distinguished Jamaican intellectual, as our birth certificate, 1834. That is when we as a people from the English-speaking Caribbean were born. We move along. Let's fast forward. In 1948, we established the University of the West Indies in Mona, in Jamaica. For the first time, we began to train professionals. We began to train doctors. Before the early 1950s, every single doctor who practiced in the Caribbean would have been trained outside the Caribbean. In the early 50s, we began training our doctors. And we have produced brilliant doctors. We no longer produce them in Jamaica. We also produce them in Trinidad and Tobago. Many of you have gone to the doctor, and the doctor that you have seen, the doctor who was attended to you, was trained in the West Indies by Caribbean people. The treatment that you got was no less than the treatment you would have received if you lived in the 40s and 50s and were treated by doctors who were trained in Europe or North America. In 1951 in St. Vincent and the Grenadines, I'm not sure what is the exact date in Antigua and Barbuda, but in the early 1950s, we got adult suffrage. So we were no longer just free people who didn't have a voice in choosing the persons who would make laws for us. We now were able to elect persons to represent us without having to meet a qualification that said you must have a certain amount of land or you must have a certain amount of money. That was a very significant advance in our process towards self-determination, adult suffrage. But although we had the right to vote, we could not vote for persons who would execute the laws of this country as they pleased. We were still colonies. And so that right to determine how the taxes that were paid should be spent, that was still determined by the colonial office in the United Kingdom. So we were still not free. Although we didn't have the shackles, that went in 1834, and although we could now vote for people in the colonial legislative assembly, but we were still not free. In 1967, we got what is called associated statehood. And there we attained a significant measure of freedom because we were then allowed responsibility for all our local affairs. But we were still semi-colonies. Britain retained responsibility for foreign affairs and for defense, so that the chief minister could not say, well, I want to go to South Africa, or I want to go to North America, I want to go to Canada and establish relations with them so that they could buy our produce and we could buy theirs and trade. You couldn't do that. In 1975, we began producing lawyers in the Caribbean for the first time. Before 1975, every lawyer that you dealt with, if you were old enough, was trained in the United Kingdom or somewhere else. But in 1975, we began producing lawyers. And we produced some excellent lawyers. Mr. Justin Simon was one of the first lawyers that we produced. Mr. Dennis Morrison from Jamaica, he was also in the first batch. I was in the third batch. And yes, I have a bias to say this, but I will say it nevertheless. The lawyers that were produced by the University of the West Indies and the law schools in the West Indies were no less capable, no less competent than the lawyers who were produced in the United Kingdom. Because good brains, aptitude, the ability to solve problems is not unique to any race, is not unique to any nationality. All of us are blessed with brains, and if we nurture that, if we apply it, and if we are given the right opportunities, we could shine just as much as anyone else in the world. In the Caribbean, we have produced more Nobel laureates per 100,000 people than anywhere else. The country of Jamaica, you go anywhere in the world and you hear their music being very proudly played, anywhere in the world. So what I am urging is that we as a Caribbean people are no less a civilization than anywhere else. We move along the continuum to 1981. We achieved political independence almost in full. We could elect our own prime minister, who, apart from governing internally, could go and conduct treaties with other countries. You're now responsible for the defense of your own country, but nobody going to invade Antigua and Barbuda. But we did not have control of our final judicial tier, our final judicial responsibility. That remained with the United Kingdom, with the same Privy Council that was established when we were sold like chicken and hogs and sheep in the market. Now, each nation, and Antigua and Barbuda with its, 60, 70, 80,000 people, is a nation. In the United Kingdom, you have one vote, just like the United States of America. Each nation deserves to have its own final court of appeal. But because we in the Caribbean are so small, we need to amalgamate in order to have one final court for all of us. So while the ideal situation is that Antigua and Barbuda should have its own final court, St. Vincent and the Grenadines should have its own final court, St. Kitts and Nevis should have its own final court, that ideal, you have to compromise with that, because the countries are so small, we lack the human and material resources to be able to accomplish that. In the same way, we so lack resources that even at the lower tiers, the lower levels in the Eastern Caribbean, we have had to amalgamate in order to have a local court system. So we have almost like a federal court system, the Eastern Caribbean Supreme Court. In 2005, the Caribbean community decided that we had the resources, the manpower, the finance, the aptitude, the desire, the willingness to establish our own final court so that we could complete that journey that began in 1834. And so the Caribbean Court of Justice was established. And Barbados and Guyana seized the moment right away. They said to the Judicial Committee of the Privy Council, thank you for what you have done for us. You've had good judges there, but those are British judges. We want judges who are based in the Caribbean. And I will get back to this a little later. So in 2005, we had for the first time the opportunity to complete our independence. We never had that before. That arose for the first time in 2005. And what is happening on November the 6th is that you're being asked whether you want to complete that independence or you want to continue with that little vestige of colonialism still hanging over you. The CCJ is two courts in one. One court deals with the CARICOM Treaty. We interpret and apply the treaty. The treaty is a document of 200 and something pages. It's a document that was negotiated among the states of CARICOM. And when states negotiate a document, usually the language is a little vague because each state wants to put in this and wants to put in that. And so at the end of the day, you have language which sometimes is not very clear. And so you need a body that will give an authoritative determination, authoritative interpretation of what the words in that treaty mean. It wouldn't be any good if you left it to the courts in each country to determine the words of the treaty. Because the courts in Jamaica might say one thing, and the courts in Trinidad might say something different. The courts in Antigua and the OECS might say something different. So you needed one court. And that court is the Caribbean Court of Justice. Antigua and Barbuda and the citizens of this country, all of you here, are members of the court so far as that Caribbean treaty is concerned. So that when Shanique Myrie, a young woman from Jamaica, traveling to Barbados for a vacation, who was humiliated at the airport, denied entry, placed in a cell, deported the next morning, she recognized that there is a CARICOM treaty that gives me, as a Jamaican citizen, even though my country has not been sending its appeals to the CCJ, nevertheless, because the CCJ is a treaty court, I have rights and I am going to take the country of Barbados to court. She brought an action before the CCJ. And you know, if you would believe what some people are telling you, if you would believe what some people are telling you about political interference, then the result of that case should have been that, well, sorry, little lady, because this was a lady who didn't have any means, any substantial means. This was a lady from very humble background. The lawyers in Jamaica did her case free. If you were to believe what I'm hearing from some people, then this court, which is rife with political interference and cozying up to all the governments, would have simply said, well, Frondel, you know, we understand what's going on. This lady doesn't have any case. That is not what happened. The court made a determination that was against the state of Barbados, and they weren't very happy about it. The court ordered Barbados to pay the lady $75,000 US. They weren't happy about that either. But guess what happened? They paid the money. All of the judgments issued by the Caribbean Court of Justice have been paid in full. Every single one. Because we have instituted a mechanism for monitoring our judgments. When we issue a judgment, that is not the end of the case. We ask the parties to come back to us in 6 months' time. And the party who has the obligation to do something or to pay money must indicate in 6 months' time, have you discharged that obligation? If you have not, why haven't you? And when will you discharge it? And we have found that to be a very effective way of ensuring that our judgments are honored. And so over the last 13 years, every single one of the judgments that we have passed has been honored. The second area, they call it a jurisdiction, that we have as a Caribbean court is the appellate jurisdiction. That is where we make ourselves available for countries to send their appeals to us instead of sending them to the Privy Council. As I said, there are 4 states that currently do that: Barbados, Guyana, Belize, Dominica. Now, not only here, but I am from St. Vincent and the Grenadines, as you heard, and I had this kind of interaction with Vincentians about a month ago. Town hall meeting just like this. And people said the same thing. We have fears. We don't know whether we can trust. We have concerns. And that is good. That is healthy. Because if you go through life without being cautious and without having reasonable fears, then you're likely to do something stupid. But how do you deal with fears? How do you deal with the issue of trust? You know, I live in Trinidad, and you hear about the crime situation in Trinidad. If I were to say, boy, there are plenty gunmen in Trinidad, I'm not coming out my house, I will make myself a prisoner. If I were to say, okay, I'll come out my house, but I'm not going down into Port of Spain, I will deprive myself of some of the pleasures of going around the savannah, jogging around it like other people do. The point I'm making is that when we have fears, we need to address them rationally. And how do you address fears rationally? You look for the facts. You look to see what are the facts. So it is all well and good to scream about political interference, but what are the facts? As I said, over 13 years, the court has been dispensing justice. So we have a track record. This isn't a court that started yesterday or day before yesterday. It's a court that's been in operation for 13 years. What are the facts? Well, I will tell you one of the facts. Same Barbuda. The Friday before Mother's Day this year, we got in an appeal, and this is a story that tells you a lot about the CCJ. Because, you know, in order for Caribbean people to believe in a Caribbean product, it has to be 10 times better than the British equivalent. And we recognize that. And we have been prepared to rise to that challenge. On the Friday before Mother's Day, at 5:30 in the evening, we received an appeal for filing. Now, let me tell you a little bit about our filing. We have one of the best electronic filing platforms in the Western Hemisphere at the Caribbean Court of Justice. You can file a case from your home, from your bedroom, from your iPad on the beach. You can file a case, well, you could submit a case for filing anywhere in the world, once you have internet and the appropriate device. So at 5:30 in the afternoon, that Friday evening, a case was submitted for filing. Now, they were a little bit lucky because our filing officers on a Friday afternoon have no business being at the court at 5:30 in the afternoon. But they were there. And it tells you a little bit something as well about the court, about the dedication of our staff. They were there, and they saw this record of appeal come in. And when they read it and saw what it was about a person in Barbados who was claiming the right to vote in the upcoming elections in Barbados. And those elections were going to be held in about 10 days away. Normally, an appeal that is processed quickly might take about 3 months, 4 months. But if this appeal took more than 10 days, then the person's relief, if they were to succeed in the appeal, would be rendered obsolete, otiose, nugatory, null, because they wanted to vote in the elections in the next 10 days. So the registry officer called me on the phone. Fortunately, again, Friday evening at 5:30, I should be home with my wife. But I happened to be there. Justice Saunders, we have this appeal. It looks like an urgent matter. I need you to come down and, well, we're going to send it up for you. In less than 2 seconds, I had it on my laptop. I read it, and I realized it was an urgent appeal. And I emailed it to my colleagues. So Dennis was not in the court at that time, or he would have been doing all of this. But I was, in a sense, the deputy president. I emailed it to them and said, this is an urgent matter. Now, that Monday, some of us were scheduled to travel to Antigua for his farewell sit-in. And so we decided we had to hear this thing on Sunday, Mother's Day. So the registry officer was instructed to accept the document for filing, to stamp it. All of this is done electronically in seconds, to return it to the lawyer, and to assist with serving it on the parties on the other side. All of this was done Friday evening. I called Sir Marston Gibson, the Chief Justice of Barbados, and I told him, we want to use one of your courtrooms to hear this appeal. We want to do it on Sunday at 11 o'clock. And Sir Marston made the courtroom available. On Sunday at 11, the lawyers were present in Barbados. The persons who wanted the right to vote were present in Barbados. Their lawyers were present in Barbados. And we were present, dressed up in our robes, Sunday morning in Trinidad, and we heard that appeal by video conference. And we gave a decision at 2 o'clock. We issued the order on Monday morning early, and in the order we told the registrar, if you don't register these people to vote, we are going to hold you in contempt and send you to prison. She registered them right away. The Prime Minister of Barbados was extremely upset. He went on the radio and he said some not very nice things about the court. He threatened to take Barbados out of the court. Now, and this relates now to trust and to political interference. I never knew the court was so beloved by Barbadian citizens. People went on the radio and denounced what the Prime Minister said. They went on the television stations. They went on the internet. There was an avalanche of support for the court. Well, the elections were held 10 days later. And I won't go any further. So my point is that it's good to have fairs, but we need to deal with fairs in a rational way. And if we don't trust people, then maybe we should ask the persons who have dealings with them for 13 years whether they are trustworthy. What are the mechanisms that this court has put in place to deal with these fairs? Because I will tell you, in 2001, I was in Jamaica at a discussion at Mona campus, speaking to students. And out of the blue, this is long before the court was established, somebody asked me, what do you think about this plan to have a Caribbean Court of Justice to replace the Judicial Committee of the Privy Council? And I said, I have two problems. Number one, I want to know how those judges are going to be selected. Because if the judges are going to be selected by the political directorate, then I don't think that that would be something that I would support. I said, secondly, I want to know about how that court is going to be financed. Because you don't want a court where every year it has to go to each of 12 governments for a subvention. Because we know that any year a hurricane could just lick out the economy of one or more of these countries, and they simply would not have the money. I used to be the Chief Justice of the Eastern Caribbean Court for 9 months, and I know that situation, because that is how that court is funded. Each year it goes to the various states and it gets funds. And sometimes a country may not be able to pay. Not because the government is bad-minded, but they simply have no funds. We didn't want a Caribbean Court of Justice like that. And it is to the credit of the Caribbean community's leaders that they addressed those two problems. Because in the first instance, they made sure that the judges were not going to be selected by any politician. The judges were going to be selected by a process that involved a commission made up in the main of lawyers in the region, proposed by their respective bar associations. A commission made up of representatives of civil society, a commission on which there is a Chief Justice in the region, a commission in which there are 2 members of the Public Service Commission on a rotating basis. So this is a broad-based body. For the last 2 months, I have had the honor of chairing that body. So we actually have a judge to select at the end of this month. And the process of selecting a judge, I can tell you what it is. We send out an advertisement, not just throughout the Caribbean, throughout the entire Commonwealth and beyond. Because we have a judge on the court now who is not even a member of a Commonwealth country. He's a judge from Holland. We send out an advertisement. We said, we want a judge. These are the qualifications. These are the criteria. If you think that you would like to be a judge of the CCJ and you have those qualifications, those criteria, then you must do a number of things. Each of the, let's call it packages that relate to each applicant is a folder thick so. Because you have to send in, if you had been a judge before, you have to send in specimens of judgments that you have done. You have to fill out a long form. We do due diligence checks on the persons who apply. For security reasons, I can't tell you the extent of those due diligence checks. But believe me, we do due diligence checks on the persons who apply. We go through the entire dossier. And we ask ourselves, is this person a good fit for the court? And we make a short list of those who we consider to be a good fit. And we bring them in, and they face all 10 members of the commission, and we grill them, we interview them. I went through that process in 2004. I had to go through that process. And that is the process we go through with each of the judges that is appointed. There isn't any political interference in any person, in any judge being appointed. That is a system as merit-based, as transparent as anything that you could see anywhere. It's a system that you can be proud of. And in relation to the president, I must correct Mrs. Quinn Williams. The president is nominated, just as she said she would like to see, is nominated by the commission. And the heads of government cannot say, I don't want Adrian, I want Jerry. They can't say that. The only thing they could say is, I don't want Adrian. Send me another nominee. That has never happened, and it is unlikely to happen, because unlike the situation in the Eastern Caribbean, no government has a veto. You have to have more than 1/3 of the heads who agree among themselves that this man can't cut it or this woman can't cut it in order for a nomination to be rejected. But you see, and this is why in these debates you need light and not heat. You need facts and not inaccuracy. There is a simple reason why it is nonsensical to believe that there can be political interference in the appointment of the judges. What is that reason? The judges resolve disputes among states, so that they resolve disputes between Antigua and St. Lucia, between Trinidad and Suriname, between Jamaica and Grenada. So each state has a vested interest in the judges on the court being persons of competence and persons of integrity, because these are the judges who are going to judge their cases. So no individual government will ever be allowed to get away with putting on the court somebody who is partial to that government, because the other governments in the region would not want to see that. So that is where the appointment system determines that we have the best and the brightest of those who apply. The other issue was, how is the court financed? Last week I was in Brisbane, Australia at a meeting of the Commonwealth Chief Justices and Heads of Judiciary. And it is not the first time that what I'm telling you has happened. Every time I indicate to judges of other countries how the CCJ is funded, they're envious. They want to have a system just like that for their courts. Precisely because the leaders of the Caribbean people, of the Caribbean community, they know their people. Precisely because they know that people would have fears and people wouldn't trust. Precisely because of these things, they created a system that is second to none in the world. They asked themselves, what capital sum would it take if you invest it would return a yield that could keep the court running for 10 years? And they said, well, $100 million would do it. So they went to the Caribbean Development Bank, which is a super institution. Some of us keep running down our Caribbean institutions. The Caribbean Development Bank is a super institution. In 2 toots, they were able to raise that $100 million, precisely because it is a bank that has worldwide acknowledgement as a bank of integrity and a bank that is run on sound financial principles. They raised that $100 million, and then they said, well, you all need to pay us back, the various states. So Trinidad and Tobago, I'm sorry I don't have the exact figures, but Trinidad and Tobago, which has a very robust economy, they had oil, you would have to pay back 30 million approximately. Jamaica, you have the most people, you have the largest economy, so you have to pay back about 30 million. Antigua and Barbuda, you only have 60, 70,000 people, so you pay back 2.9 million, and so on. But each paid according to their means. So I keep telling people that the 2.9 million Antigua paid is just as weighty as the 30 million Trinidad paid, because it represents the same level of sacrifice for the taxpayers of that country. But the 100 million was paid back in that manner after 10 years. So right now, you have paid for a court that you're not using. Where in the world does that make any kind of sense? You have paid for a court that you're allowing other people to use and you're not using. I am hearing, not only here, but in St. Vincent and the Grenadines, some people say, well, we need to fix the local system first, because the local system has this deficiency and that deficiency. Why do I ask the Privy Council that? They are the local apex court. Now, the CCJ,
may I just ask
the Caribbean Court of Justice is not your apex court. The Privy Council is your apex court. And if you want to compare apples with apples, then let us compare what the Privy Council is doing to help fix the local justice system with what the Privy Council is doing to help to fix the local justice system. You see, I don't have a problem with honest disagreement. But if we are going to debate something, we must be honest about it. If we are going to make comparisons, we must make honest comparisons. The CCJ is a replacement for the Privy Council. So if you are tasking the CCJ with certain things, then it is only fair and just that you task the Privy Council with the same things. So when we talk about what is fair and what is just, that is one of the things we must bear in mind. Now, the Privy Council is not well suited to aid in fixing your local justice system. They are thousands of miles away, and they frankly are not extremely interested in what problems you have in your local justice system. Their only concern is to receive an appeal and give a result. That's all they do. The Caribbean Court of Justice, on the other hand, we live among you. We know what the problems are, and we go into the various states and help to fix the justice system. So if you're going to wait until the justice system is fixed before you go to the CCJ, you will wait forever. In Guyana, now, I don't mean to act, don't get vexed with me, you know. I am just telling you facts. Don't get vexed with me. I am not telling you to vote one way or another. Some of you already made up your mind, that is fine. I just want to tell you certain facts. And if you have an open mind, then you will process those facts, or you will come back tomorrow and tell me what I said is a lie. We have been working with Guyana to help to improve the local justice system in that country. Guyana did not have modern civil procedure court rules. We helped them to establish modern civil procedure rules. The judges needed to be trained on those rules. The CCJ went in and trained the judges on those rules. The court staff needed to be trained on those rules. The CCJ went in and trained the court staff on those rules. So when I hear this, I don't mean any disrespect to the persons who say it, but it is really nonsense that you must wait until you fix the local justice system, then you have it upside down. Upside down. It is precisely because you want to have an apex court that is invested in the problems that you face in the local justice system, and that has the desire and the capacity and the resources to assist you in doing that, that you need to go to the CCJ. You know, judges and judging has two fundamental constructs. That's a big word. There are two, in my view, there are two fundamental attributes about judging. And this applies whether you're judging a boxing competition, you're judging a panorama contest, or you're a judge in court. Two fundamental attributes. You must see from near, and you must judge from far. And I will explain what I mean. Anytime you see a judge, or you go to any activity, who has the best seat in the house? The judge. If this was a competition and you're judging who said the best things, the judges would be sitting down right where Mr. Watt is. Because you need to see from there. You need to be able to see the action precisely as it unfolds. You need to see all the nuances. You need to be able to get the best possible view of what is taking place. The same thing is true about a judge in court. The judge in court has the best seat in the house. The judge needs to be able to see the witnesses very clearly. The judge needs to be able to get the best possible look at what is unfolding in the court. How does that apply to appellate courts? Appellate court judges need to be conversant with the culture, the language, the aspirations, the goals of the people whose cases they are judging. That is how you apply seeing from near to appellate courts. The Privy Council can't do that. They are all the way across the Atlantic. They have a different culture. Some of them may never have been to Antigua and Barbuda. They are not able, and they say that in their judgments. They say that in their judgments from time to time, that they are not well placed to determine certain issues. There's a case, Pandey versus Gordon, the former Prime Minister of Trinidad and Tobago, Mr. Basilio Pandey. Mr. Ken Gordon, who is a very reputable former media owner in Trinidad, complained in the courts that Mr. Pandey had slandered him by calling him a pseudo-racist. He brought an action against him for defamation. The trial judge said, yes, pseudo-racist is very damaging to your reputation, Mr. Gordon. I find Mr. Pandey liable, and he must pay, I can't remember, hundreds of thousands of TT dollars. Mr. Pandey appealed. He said the judge got it wrong. Pseudo-racist is no big deal. And in any event, even if it is slanderous, that amount of money is too much. The Court of Appeal said, no, pseudo-racist is a serious thing. You can't call a man a pseudo-racist. But I agree, the money is too much. We will cut it in half. Mr. Pandey was still dissatisfied. He went to the Privy Council, and he had the same arguments. Pseudo-racist is not a slanderous term. Even the half, even if you find that pseudo-racist is a slanderous term, the half was still too much. You must look up the case, those of you who have access to the law reports. Pandey versus Gordon. The Privy Council said, well, on the first issue of pseudo-racist, we are far removed from the situation in Trinidad and Tobago. And it is the judges in Trinidad and Tobago who would know best what is and what is not damaging to a man's reputation if you call him a pseudo-racist. So on that ground, Mr. Pandey, we wouldn't interfere. Mr. Pandey said, well, what about the money? The half is too much. He said, well, you know, money is something that the people who are living in the country where that money is being spent are best able to determine the value. And so we will not interfere with what the judges below have said. Pandey versus Gordon. In effect, Mr. Pandey, his appeal was otiose, null, rendered obsolete, because the Privy Council judges recognize they can't see from near. Now, the other construct is judging from far. Oh, the Privy Council is wonderful at that, because they are physically remote. But the thing about judging from far is that you don't need to be physically remote in order to be detached, in order to be impartial, in order to be dispassionate, in order to be objective. Those qualities are states of mind. And any judge who is trained is able to judge from far, even if the judge is at the same time seeing from near. Indeed, that is what every judge does. But the Privy Council is unable to fulfill one half of that equation. And they recognize it, and they say it from time to time. We in the CCJ are so sensitive to the fact that Caribbean people need access to justice that we have something called a poor person's application, so that if you earn less than a certain threshold amount and you're not too ashamed to say that you are a poor person, the court will relieve you of having to pay filing fees. The court would relieve you of having to pay the security deposit, which every person appealing normally would pay. And the court would go further, as we have done in some cases, and ask the Bar Association of your country to provide free legal representation for you if we think that your case is one that has merit in it. There was a case from Guyana, Ross and Sinclair, where we did precisely that. These are litigants who would never make it to the Privy Council. Never. And when a litigant is deprived of being able to pursue an appeal that has merit, it's not just the litigant who is suffering. It is the whole jurisprudence that suffers, because the court is denied the opportunity to shine a spotlight on a gray area of law which requires a final court to pass its judgment on. So when over the last 30 years, only 37 cases from Antigua and Barbuda have made it to the Privy Council, it is not only the hundreds of persons who would have liked to have appealed but could not have afforded to, who are being frustrated. It is the jurisprudence of Antigua and Barbuda that is also being frustrated. So that when we consider the respective merits of the CCJ and the Privy Council, I told Tory this morning, I am willing to listen to a good argument why a Caribbean people should not delink from the Privy Council. I am yet to hear one. I don't understand how it is that we can be content to grow up children and to say to them, if you want to be a lawyer, that is fine. You want to be a judge, that is fine. You want to sit on our nation's final court, that is not fine, because that is reserved for Englishmen and women. How can you say that to your children? Have we no pride? Are we any lesser than anyone else? Don't we have the same competence? The same level of integrity? I believe that in every civilization, you have persons of integrity, and you have a few who lack integrity. If anyone believes that in the United Kingdom there aren't persons who lack integrity, then you have a sad, sad, sad people. So, I want to take my seat now so that I could hear your questions. But I want to end by saying this, that this issue is really, it should not be a political issue. When you talk about independence, you talk about emancipation, you talk about adult suffrage, those are not political issues. Those are not issues between one set of us and another set of us. Those are issues of the whole society. We ought not to be fighting against each other on an issue like that. This is supposed to be an issue where we proceed as one, gratefully, quickly, robustly, to reclaim our full independence. When I sit down and ask me the question, I'll tell you about it. You see, it is very difficult to argue the case for delinking from the Privy Council. You know why? Anytime a case goes up to the Privy Council and the appellant succeeds, thank God for the Privy Council. They are the best. Oh my. It doesn't matter if the CCJ would have given the same decision. It doesn't matter if the Privy Council 5 years afterwards said, well, that decision we gave 5 years ago was actually incorrect, you know? If, on the other hand, an appeal goes up to the Privy Council and is dismissed, as the case of Isaacs was, the Privy Council held that the decisions of the courts below were correct. Well, everybody said, well, nothing, that's no big deal, you know. So you can't win. You can't win. We need to get beyond that kind of pathology. Ladies and gentlemen, I took up a lot of your time, I'm sorry. But as you could see, this is something I feel very passionate about. And I thank you for listening to me, and I look forward to your questions.
Thank you very kindly, Mr. President. I, for one, Mr. President, have read most of your judgments. Ever since, Mr. President, you were in the Eastern Caribbean Supreme Court, and when you acted, sir, as Chief Justice. Our final speaker will be the Honorable Prime Minister of Antigua and Barbuda, the Honorable Gaston Brown.